starting to run a little bit behind schedule now. If I look at the clock, it's 9:37. Elvis is with us with another update.
Thank you, Yeb. And our reporter is in Bloemfontein. We talked to Mangobo Mkhunu, who's standing by. Mangobo, earlier when we spoke, there was a lot of activity with the ANC Women's League around you. Can you paint us a picture of what's happening now?
Well, certainly, Elvis, we're now just moments away from the start of this hearing here at the Supreme Court of Appeal. And just behind me, I'm now inside, Elvis, just to put you on, to understand where I am. I'm now inside the court precinct, and just behind me is the court in which that particular appeal will be heard by the Supreme Court of Appeal. A full bench of judges is expected to listen to the appeal, and they are being led by the President of the Supreme Court of Appeal, who is Lex Mpati. But basically what's going to happen now is that the state will try to convince the court that they should hear this matter, and basically to try and argue that Oscar Pistorius should get a much harsher sentence for killing River Steenkamp. And their argument is basically that he was given a very light sentence by the High Court, and they believe that Judge Thokozile Masipa erred in finding Oscar Pistorius guilty of negligently killing River Steenkamp. But we do understand that there are certain issues that first have to be addressed by the Supreme Court of Appeal before the actual hearing can be heard. And to discuss them further, I'm now joined by a legal analyst, Brenda Wardler, who is also observing this case very closely. Brenda, just firstly to take us through, what is the first hurdle that the state will now have to deal with before presenting its merits on the case?
As the appellants or the applicants in this matter, the state needs to cross the hurdle of whether or not the questions that they've reserved for determination by the Supreme Court of Appeal are in fact questions of law, because they are not allowed, their right to appeal is limited in terms of Section 319. They may only appeal on questions of law and not of fact. Immediately they've crossed the hurdle of questions of law, half of the battle is won by the state. And thereafter, because those facts will then become relevant when they are discussing the questions of law.
Okay, and what happens then in a case where the court does agree with the defense to say that these are actually questions of factual findings?
Well, they might even say so, and in that case, we won't be here for very long. They would essentially dismiss the application, tell the state that, sorry, you're barking up the wrong tree, and the state might then approach the Constitutional Court. We must remember that the Constitutional Court itself has dealt with whether a question is a question of law or is a question of fact. Now, the good thing about this court where we are at today, the Supreme Court of Appeal, it's the highest court of appeal in South Africa on all matters except for constitutional matters and other matters of importance. However, this court, their decisions bind all other courts in South Africa below it, all tribunals and fora. However, this court is relatively bound by their own previous decisions. A lot has been said about Siakui, but this court can turn around and say, look, our interpretation of Siakui was incorrect. Let us revisit that decision.
Okay, and in terms of, looking into the state's case
Yes.
of appeal, do you think it has grounds to appeal?
Well, I would say on the facts, the state definitely has a very, very strong case. Unfortunately, they are limited by the fact that they may only appeal on questions of law. And the difficulty there is we talk about the vertical application of the Bill of Rights, where the state is in a position of power in relation to the citizens of a state. So when the NPA prosecutes, it prosecutes on behalf of the people of South Africa. Now, we cannot allow a situation where the state, being as powerful as it is, make errors, where they make errors at the trial phase and then rely on a right to appeal as an accused person.
So certainly we could see some sort of a precedent coming off this case if the state gets it.
Definitely, because all judgments of this court are binding precedents on all other courts below that.
Thank you very much. That was Brenda Wardler, who was a legal analyst here, also following very closely the developments here at the Supreme Court of Appeal. We have seen the state coming in just about an hour ago, led obviously by the senior advocate Kharinal, who will be putting on the fight for the state. We also saw the defense also walking into court just a few moments ago. They'll be led by Advocate Berry Roo, who's also the senior counsel acting on behalf of Oscar Pistorius, and certainly we'll be keeping a close eye on what is being said in court, and we'll bring an update certainly from here in Bloemfontein.
That's our reporter in Bloemfontein, Mangobo. As we waiting for the CSA to start in a very, very short while, and as you know that we will cross their lives, so you have to stay tuned right here on Channel 404.